This episode is brought to you by Roundtable Group, the experts on experts. We've been connecting attorneys with experts for over 25 years. Find out more at roundtablegroup.com.
Welcome to Discussions at the Roundtable. I'm your host, Noah Ballmer, and today I'm excited to welcome John Catlett to the show. Now, Mr. Catlett owns a full-service building and fire code consulting firm with expertise in management training, proposals, implementation, compliance, and more. He has a range of experience spanning over 30 years, including as a fire marshal, maintenance code official, and building plan reviewer. Mr. Catlett, thank you so much for joining me today at the Roundtable.
Well, thank you for inviting me.
Of course. Let's jump into it. You have certifications too numerous to even mention in building code, fire, and EMS. Tell me about your background and how you first became an expert witness.
Well, actually, my background, I started in local government. Actually started as a trades technician, believe it or not. I never thought that I would end up touching building codes. Was an electrician, actually. And went in the fire service, spent some time in the fire service. And at the same time, I was working in some part-time areas as a building inspector. And from there, it kind of went on. I ended up getting out of the fire service due to an injury and moved into the code stuff full time and ended up retiring as the director of building and fire codes in Alexandria, Virginia.
No kidding. And how did that lead to kind of a career as an expert witness? What was the first time that you got a call? Was it out of the blue? Was it something that you were looking for?
Actually, I had actually started the business about 2 years before I retired. Didn't do much. I did some local government stuff, assisting with some customer service issues and that kind of thing. But I actually got on with a service similar to your all's and had got my first case. And from that point forward, it's kind of taken off, and I normally do fairly well. Not something I had saw that I was going to get into. My forte kind of was in building and fire code development, writing code, representing for people, but turns out that it's been a very beneficial side for me.
Let's talk about that vetting process. When you first get those calls, you first take those calls, it's obviously not them, the attorney, or whoever's engaging you, vetting you, but it's you vetting them. What are the things that you look for, and what are the things that they're looking for?
My typical client has been one in which, number one, they go into it understanding, I am not the kind of consultant that will make your case. I will look at it. I will provide you a truthful statement. If I can assist you on your case, I will assist you. And if I can't, then I will tell you so. And most of my clients that I've actually taken on have said, that's what we want. We don't want to go into a court proceeding having somebody trying to blow it up a little bit and make it something more than it is, only to find out that we're going to get picked apart by another consultant. So that's one of the leading edges for I think our company is we take no cases unless it is we truly feel that the code has been violated or there is a good reason for us to be involved.
Besides the specifics of the case itself, how do you determine whether your particular niche of expertise fits the specific case that you're being presented with? You sometimes have kind of edge cases that you need to do a little bit of extra research on. So tell me about that process a little bit.
Yeah, absolutely. I've actually got involved with some like public works related type cases. And again, my background was building and fire code. But because I did start off in the public works sector, sidewalk cases, injuries due to falls, things like that, I didn't initially feel like I was the appropriate expert. Then when I started researching the cases, I said, well, heck yeah, I can do this. This is, definitely something I was involved with at certain times in my life. And I believe for most consultants, that's what you got to do. You have to draw back on your whole life experience. And if you do that, then you can successfully kind of branch out a little bit more than what you maybe have been focused in the last 10, 12, 15 years. And I really feel like that I had some great people that gave me great opportunities in my earlier careers that really kind of formed a basis for what I can do now.
What sorts of preparation do you do once you've accepted an engagement? Obviously, you have to write a report. You have to get a whole bunch of documentation from your attorney. So kind of walk me through a typical engagement.
Most of the engagements I have does require at least a site visit, depending on where it's located. A couple of them I've been able to do based on pictures. It may be like a specific question. I recall one that dealt with anchorage of a maintenance ladder on a building. And so I didn't need to actually physically go look at it. They provided me the pictures, and the question came down about the fasteners that were used. But in most cases, you're going to go on site. You're going to spend some time looking over the total building. And the reason I say you look at the total building is you might be focused on a fall injury or a partial collapse in a building, but you also want to get a general feeling about how especially if it's a building that recently went through some sort of alteration or a change of use. I had one in particular, was a change of use from warehouses to residential. It was loaded with code violations that had nothing to do with the case I was working at, but it gave me the background to let me know that these folks weren't looking to be fully compliant and work in that area and try to make sure things were okay. So make sure that you don't keep your focus to the immediate thing that you're doing. Secondly, document. You want to make sure that you take plenty of pictures, take more than you think you will ever need, number one. And number two, make sure that you go back and you tie it to the appropriate area of either the code, in my particular case, or if you're a consultant in another area, whatever your field is. It's opinions are great, and I can base a lot on opinion sometimes because I did have about 35 years of experience in local government doing this stuff. But opinions don't go very far. Judges want facts. And, I think once you get into a courtroom, you will realize that if you sit there and did a lot of opinions, people can pick apart your opinions. But if I show a hard and fast, this is the code, this is what it violated, and that's it, the judges typically will not. You're good as gold at that point.
Have you done work for both the plaintiff and defendant side?
I have. It's very interesting. One of my very first cases that I worked from it, I actually received 4 other cases from the attorneys that were involved on the other side. And so it was very interesting that, you end up going into that realm of, especially when you're dealing with people that, maybe trips and falls and things like that. Some of this does come down to things like you do have to be aware of your surroundings. And I advise, my clients a lot of times that make sure you understand that, just because there's something and they fell doesn't mean there was a problem. And so I think that that's one of the things that you want to make sure is going with clarity with your client. Typically it's an attorney. There have been a few cases that I've worked directly for the plaintiff. Actually was hired by one and then brought his attorney on board. And then sure. I do other work that's outside of anything involved with legal aspects. I would just advise anybody, though, treat everything you do the same, because you never know when you think it's not going to be something that's litigated. The next thing you know, there's litigation. And so even if you're doing an advisement on something, I've sat at tables where somebody said, well, if we can't get this figured out, we're just going to go to court. Well, guess what? You want to make sure you treated it the very same way that you would if you were going into it knowing that it was litigation.
Yeah, you bring up a good point. There's 2 types of expert witnesses. There's your consulting witnesses, and then there's your testifying witnesses. But sometimes that line might be a little fuzzy and one might become the other. Is that something that's happened to you with some frequency?
Absolutely. The one case I was mentioning earlier, or the ladder issue, that was about a very specific part about something that happened. A ladder had come off of a building and someone had fallen and got severely injured. And it was a maintenance ladder that was to be permanently affixed. Well, I was dealing with the issue of the bolts. And, so I was the consulting person in that role. However, if it went to trial and this one did not, I would probably have ended up going in and actually testifying about what my findings were. So sometimes you can start off kind of as a consulting witness, and then next thing you know, you're involved and you're actually being deposed, or you're actually in front of a judge.
Along the same line, there are obviously you've worked both for plaintiff and defendant, and as you know, there are both initial reports and rebuttal reports, which often tie in with whether or not you're on the plaintiff or defendant side. You said that you take the same approach whether or not you are a consulting witness or a testifying witness. Do you take a different approach in your report writing on whether it is an initial report or if it's a rebuttal report?
Typically, the initial report is going to be more thorough, and again, that's why I said take plenty of pictures, take lots of notes. You want to make sure that you're very thorough in your initial report. What you will find sometimes is you will be going up against other consultants that are hired on the other side to pick apart your report. And so it has to be as solid as possible. So I would just warn anybody who is in the business to just make sure that you treat them kind of both the same. Now, typically in rebuttal, you're going to be focused on specific things. You may be rebutting them and their initial report, or you may be doing a rebuttal to their rebuttal of your report. So a lot of times at that point, then you can be a little more focused and detailed in what your response is. But initial reports are normally very broad and very focused. And then from that point forward, then you do get into that, I will call it litigating without the judge. So.
Do you have a couple stories that you can share of engagements that somehow impacted the way that you view or approach expert witness work?
Absolutely. And actually it was something that when I initially got into the business, I said I probably would not do. I would probably not get involved with litigation cases. The very first case I was asked to be involved with involved an injury. A young woman in her 20s had fallen 5 stories in a building through a shaft that she should have never had access to. And I was so compelled by what had happened to her. She ended up being a paraplegic from that point forward. And with this particular attorney, I have a great relationship with them now. I've done several cases for them. Nowhere near to this level. This one was a multi-million-dollar case. But I remember going into deposition and the attorney saying to me, have you ever been deposed before? And whatever. I said, well, I've been deposed, but never as a consultant. It's normally been from the governmental side. She was so nervous. And there was 4 attorneys for the other side. I mean, it was one for each entity and then for the insurance companies. When I got done, I came out and she came and hugged me so hard and said, I have never heard such a good deposition in all my life. You nailed it. And a week later, settled. And so, I really, again, kind of felt that even in that regard, being it was my first time around, I really did not feel nervous. I felt I was there to tell the truth. If you don't put yourself in a bad situation, meaning that you've stretched what you feel your findings are, you can always feel comfortable going in. And if you're comfortable, then you're going to nail it. I mean, plain and simple, there's nothing they can do to pull you off track. And they do. They will try their best to pull you off track. And they, all you do is you go back and say, you mean except for this one issue? And then they stop, And so it was a really good case. And from that point, it's really gotten simpler. I will just advise everybody that when you're dealing with a case that, the attorney's kind of feeding you information, make sure they give you everything. I did get stuck on the stand once in a situation where there was a document produced and I had not seen it. And I really couldn't answer for it. And it wouldn't have changed the outcome a whole lot. But it was bad to be sitting on the stand and going, I had not seen this document. And the question that you asked me, I would have to answer yes to. However, and then what it turned out to be, it was taken out of context. The document was something that really shouldn't even have been introduced. But the attorney came to me after and said, that's my fault. That's my fault. I should have given that. I should have gotten it to you and we should have discussed it. So just make sure, that you think about asking those kind of questions to your client. Have you given me everything? Is there something that could come up that, I haven't been prepared for or you haven't prepared me for? And if that happens and occurs, you just have to figure out the best possible answer, including, Your Honor, I don't know. I have not seen this document before.
So you recommend a fairly proactive approach with your hiring attorney. You like to ask them lots of questions and make sure that you're well prepared.
I do. And I stay in regular communication with them. If a case gets kind of, put on a back burner for a while, or if it's a long time out, I don't bug them in between. But when it gets closer to the time, if I haven't heard from them, I'm like, where are we? Are we, ready to go? Are things ready to happen? And in some cases, they'll come back, oh, we already settled that one, sorry. And in some cases, they'll come back and say, glad you got a hold of me. You're on my mind, my to-do list. And you want to kind of, to some degree, drive the timing a little bit, because if somebody waits till the last minute, no matter what you're doing, whether it's getting ready to go on a trip or doing consulting and dealing with attorneys, you don't want to make your planning at the last minute, because that's where mistakes get made.
I've heard from several witnesses that they wish that their engaging attorneys would start that engagement a bit earlier. Have you been in situations where you felt a little bit rushed to get everything together?
I have, not too frequently, because again, I've been very fortunate to have some of the same clients come back to me. And so we have a good working relationship. And again, I don't feel funny about picking up the phone or sending them a text message or something. I'm always careful to make sure that nothing goes in an email or text that is discoverable. It could be a simple question. Hey, do you got a few minutes? Could we chat? Or have you heard any more about a date on this case? And then that'll start a conversation where you can be a little bit more open. But yeah, I like I said, I think it's important that not bugging this, every attorney has got probably a big caseload out there. And if they're dealing with the kind of cases where they're bringing you involved, they're not, just sitting around waiting for an ambulance to pass by. So, what I have found is don't be afraid to remind the attorney that you're still out there, and that, hey, I want to make sure we get this and get what you need as soon as possible.
Sure, exactly. Since you've had positive engagements on depositions, tell me a little bit more. I want to dig into that a little bit more. What makes a good deposition? What can you do as an expert witness to make sure that process is as stress-free, which I'm putting in air quotes, as it possibly can be? And how do you deal, especially under a situation like cross-examination, with the kind of inherent stress and some of the opposing attorneys' tactics that they'll use to throw you off a little bit?
Yeah, that does happen quite frequently. Again, I think it goes back to being solid in your knowledge of what you're doing, preparing, the 3 Ps, making sure that you don't try to remember what you wrote 3 months ago, the day you're sitting in a deposition. You want to make sure that you've, within the week prior, that you've gone back through these things, because a lot of times these cases get drug out. And from the point you did your initial report to the time you're in depositions could be 18 months later. And so it's very important that you, even without anything going on, particularly with the case, pull it out, look through it again, refresh your memory. Because the more you do that, just like with anything, is how we learn. If you go into a case and say, if you look on page 5 of my deposition without going to your of my report, without going to your report, you're going to look and go, oh crud, this guy's prepared. And so I have really found that the way a lot of attorneys will try to pull you off is to make partial statements about something that you would put in your report. And they'll come back and they'll say it, because of course then they're on record and they say it. And what I've been able to do is go back and basically say, yeah, you're right in your statement, but if you read my entire statement out of my document, this is what it says. And it generally is shut them up. I mean, at that point, there's not a lot of recourse, when they do that. And you can typically see when an opposite side has gotten the consultant, and the consultant feels it's their job to make their case no matter what. And in those cases, it's so easy to pick that apart. If you're solid in your knowledge, you'll sit there and see it. In my particular realm and field, dealing in building and fire codes, it's kind of like a lot of people get home inspections done. And a home inspector puts everything out there on this report. The thing is that the code would not require you to meet all those requirements. You know, they're taking the latest code and saying, well, I should have a GFI outlet in the bathroom. And I would take that report and say, nope, the only thing I got to have is this and the things that are required in the maintenance code. And so, you know, what you want to do is you got to be careful, because people will do that. They'll try to pull a newer version of, you know, in my case, it's building codes, and they'll sit there and say, well, the 2021 code says this. Yeah, but this thing was built, you know, back in 1986. And so we can't use the provisions from there. And it's really just interesting to see how unprepared sometimes the other consultants can be.
That's a really interesting point. You have, you know, with such a vast expertise, surely there's a lot of code, and a lot of it, you know, must change, like you just said, from the 80s to the 90s to now. How do you stay on top of all of that? What does it mean to remain an expert in your field? Are you constantly just researching code? Do you attend classes? Do you teach classes? What are the methods that experts, not only in your field, but in general, should be doing to enhance and improve their own expertise?
I'm fortunate because, again, when I first came into the consulting business, I had just come out of local government being an enforcer. And for probably the last 25 years or so before my retirement, I was heavily involved both on the state of Virginia level and also the national level in code development. I served on code committees. I was one of the people that you brought code changes to, and whether approved them or not, I wrote a lot of code provisions in the state of Virginia. And so that kind of helps. And that's what a lot of my other side of the client base is. I do that kind of building code and fire code. I submit things on their behalf. I defend things on their behalf, and that keeps you in the code. I mean, when the code is constantly changing, the best way to know is be involved in the code development process, because then you are there when the discussions happen. It also makes it a little bit better too as you move along, because sometimes you can take things you've heard in testimony at the code development hearings and use it as part of a court case. And, you know, if the line in the sand was drawn here, but really it didn't make a whole lot of sense, being a half an inch this way or that way really doesn't matter all that much. And sometimes you can bring that level of expertise in that someone else who's never been involved with that doesn't have. They don't know the background. They don't understand how codes are developed.
One of the other things that you mentioned that I wanted to follow up on was, you said, you know, prepare, prepare, prepare. Those are the 3 Ps. What sorts of specific preparation methods, other than what you obviously said about making sure that you've read recently? For example, do you do mock cross-examinations or anything like that?
I have in the past, depending on the attorney and really the size of the case. The very first one I was involved with, we did do some of that kind of prep. I was very fortunate that back in my days when I was a local building and fire code official, the state of Virginia had a great program. It was called an advanced officials module, and one of the things we did was a courtroom. And so, you know, we were taught about it and everything else, and then we actually went into a courtroom in one of the counties around Richmond, and we had a mock trial. And so, you know, there's lots of ways to do it, whether it's specific to the case or not. I would say for anybody who has never been to court, they probably should do something like that, have some sort of preparatory training about what to expect. You know, what happens when somebody objects, and, you know, do you shut up or you keep talking? I mean, it's just simple things like that. If you're not familiar with how courtrooms work, you can get yourself in trouble. And at the same time, you also don't want to say something that your attorney doesn't want you to say. And so that's sometimes when they will object for you, and, you know, make sure that things stay on track.
One of the things that I'd like to, you know, pivot to before we wrap up is positive experiences. What makes you and the attorney a good team? You mentioned a few things. You said that attorneys prefer when you're there to essentially tell the truth, not to be a cheerleader for them. What are the other things that make a positive relationship that you're going to get repeat engagements, you're going to help them on their case as much as possible?
I kind of find the same thing with attorneys as I used to feel about local elected officials when I was in local government. And that is, sometimes it's better to tell them, you ought to step away from this one. Sometimes you will end up with a situation where you've got an attorney. Sometimes they're not as experienced as most of the ones that I deal with. But sometimes you'll get an attorney and they'll bring you a case and you'll sit there and say, well, I'm just going to tell you, there's not much I can do for you because there's really not much you can do. And what I have found from the attorneys that I work with, they value that. They want me to tell them that because they don't want to go down a path and think that there's something there that's not there. And they don't want to promise a client that they've got something that's not there. And so I have found that it is the relationship I have with just about every one of the attorneys I've ever worked for is if they call me up with something, I sit there and I say, this is a freebie, my friend. You don't have anything here. Really, to be truthful with you, we can't make a cake out of mud. And so we're just not going to get there. And a lot of times they'll sit there and say, thank you, send me a bill. And no, I'm just telling you right up front, I don't think you got anything. And in just about every instance, they've let me know, yeah, we've dropped this one out. We're not going to go after it. If they were to have continued on and get somebody else, that would make me feel like I had not done value to them with the services I offer. I'm only going to tell you that if I really feel like, again, there's just no avenue for you to take your case where you think it should go.
Does that typically come up in the initial call?
Yes. And again, most of the time when especially with my repeat customers or my folks I've done multiple work for, it comes up. They know how I'm going to act or react. I will actually normally do my initial research and tell them, say, give me a call. Again, you don't just send things if you're not used to this process. One of the things the attorneys will really advise you is don't send anything we don't ask you to send. And so, it's very important that you say, hey, I'm ready when you are. Can you give me a call? And then what I'll do is I'll go through my initial research with them. And I do that for those clients. I don't expect them to pay for that. It to me is how I keep really good relations with these people. They know I'm going to let them know basically what I think up front with the initial research. And then from that point, if they're going to move on, then they engage me and we go from there.
So turning down, a small number of potential engagements can become more engagements going forward, right?
Mm-hmm. Absolutely. I think that's the thing you have to realize. Sometimes there's no winners out there and you should step away from them yourself. It's to me, it's not about the money. It's about fairness and equity. And I think that whenever I look at a case, I try to look, who was aggrieved. And, was this person acting normally? If it's a personal injury, not all of them are personal injury cases. I mean, I've had several that are just construction related issues. But, in those cases, somebody still is aggrieved. And that's the person who was expecting the end product that didn't get what they expected. And so I always try to keep that in mind when I'm going in, and I try to think about it in that realm and not about, well, how much money is this going to bring me or how much this. It's about what can we do to get justice for this person, and this is what I'm going to try to do to help and assist with that.
Do you have any last tips for newer expert witnesses or attorneys working with expert witnesses?
Well, I think if you do it right, then you end up at some point thinking that you probably should have become a public defender because, that's sort of the realm that I end up taking. Again, I'm trying to look at the victim and the witness or a prosecutor, anyway, one of those two sides. But I would also just tell folks that you're better off probably not to be just uni-focused on one area, and that's litigation. The more broader your practice is, the more knowledge that you have, the more you bring to your litigation cases. And so I don't know too many consultants in my field that actually focus on litigation cases. When you find the people that do, you will find that those are the people where you can really put them to shame with their reports and the things that they've put out there. And so I would just, like I said, it's to me, it's kind of an outcropping of what I've done my whole life. And so it makes it a little bit easier for me to kind of feel comfortable in my own skin when it comes to these cases.
Sage advice. Mr. Catlett, thank you so much for joining me here today.
Well, thank you so much. I really enjoy it. And I love the roundtable and look forward to doing more with you all.
And thank you to our audience for joining me for another discussion at the Roundtable. Cheers.
Thank you for listening to our podcast, Discussions at Roundtable. Our show notes are available on our website, roundtablegroup.com. Subscribe today on Apple Podcasts or your favorite listening apps.